Good afternoon. My name is Kristen Corshado-Maddie, and today I'm going to review and provide a case brief on case Rajesh Idnani, um, EAI versus Venus Capital Management, case number SUCV 201001280BLS2. Commonwealth of Massachusetts Superior Court, Suffolk SS, November 30th, 2011. We're going to start with the relevant facts first. This dispute is between the parties concerning management fees and ownership interest in certain hedge funds that were managed by the defendant. After prevailing in arbitration, the plaintiffs filed an action contending that the defendants had engaged in fraudulent activity and otherwise wrongful conduct intended to deprive them of obtaining the benefit of that arbitration award. The plaintiffs now contend that the defendants have intentionally destroyed evidence and seek sanctions, including default judgment. Next, we're going to review the substantive facts. The plaintiff's retained company named Evidox, which provides electronic discovery services. Evidox arranged an appointment to collect documents from Venus Capital Management, Inc., and scheduled a time to do this. Although Venus was aware that Evidox was scheduled to come at the specified date, within days of the scheduled e-discovery date, the Chief Executive Officer, Mr. Marotra of Venus, destroyed the documents, stating he thought those documents were irrelevant. Prior to Evidox securing time to perform the e-discovery, the defense counsel advised his client, both orally and in written form, the need to preserve all records. The procedural facts, the decision to destroy the material was in direct violation of the instructions Marotras had received from his own legal counsel. In addition, the court does not credit Mr. Marotras' claim that this was part of some regular cleanup or to free up storage. Upon the destruction of the material occurring, the defendant's attorney notified the court that the destruction of the material had occurred and withdrew from the case. If a litigant knows that the material is relevant, they have to preserve this. Applicable laws. When this came to the attention of the defense counsel, Anthony Bongiorno, he conducted his own investigation and determined that the canons of professional conduct required him to disclose this to the court and the opposing counsel. At a hearing held on July 7, 2011, Bongiorno informed this court that his investigation had determined that, in fact, his clients had destroyed documents which were responsive to the pending Rule 34 request of the plaintiffs. Bongiorno withdrew from the case, with new counsel entering appearance. After some period of discovery relating to the spoliation issue, plaintiffs filed the instant motion. The remedies sought are, number one, the plaintiffs contend that the defendants have intentionally destroyed evidence and seek sanctions, including default judgment. Number two, the defendant to appellee. In sworn testimony, Marotra stated that many of these materials had nothing to do with instant litigation. The issue is that number one, sanctions are appropriate with the court given considerable discretion to craft a remedy that will address the precise unfairness that would otherwise result. The judge should impose a sanction necessary to remedy the prejudice to the non-spoliating party. Number two, the willfulness of the conduct in question should be taken into account. In the holding, this court concludes that Marotra's conduct cannot go unsanctioned. The conduct was intentional, and given the circumstances, in bad faith. The judicial system depends in large part on the integrity of those who participate in it. Whenever relevant evidence is destroyed, that has a pernicious effect on the truth-finding function of the court. Also, this kind of conduct imposes significant costs on opposing counsel, and it requires the expenditure of judicial resources. It should not go unpunished. Accordingly, it is hereby ordered that, number one, defendants shall pay all attorneys' fees and costs incurred by the plaintiffs in connection with this motion. Plaintiffs shall serve on defendants within 14 days a motion seeking specified amount, accompanied by an affidavit detailing such costs and expense. Defendants may respond within 10 days thereafter, with the papers filed in the manner provided by the Superior Court Rule 9A. Number two, at the trial of the plaintiff's claims, the court will permit plaintiffs to introduce evidence of meretricious conduct as set for herein. The court will instruct the jury that it may infer from that conduct that additional relevant materials existed and were not produced as a result of meretricious conduct, and that such materials would have provided evidence facts supportive of the plaintiff's claims. The reasoning behind this, the decision to destroy materials was in direct violation of the instructions he had received from his own counsel. In addition, the court does not credit Mr. Meretricious' claim that this was part of some regular cleanup or to free up storage. Upon the destruction of the material occurring, the defendant's attorney notified the court that the destruction of the material had occurred and withdrew from the case. If a litigant knows that the material is relevant, they have to preserve this. The court sanctioned with the defendant and notified jury of this conduct and of the destruction of the documents. The rule of law was Rule 34. Evaluation. Upon my personal evaluation and in my humble opinion, this case was correctly decided, as all parties in any case are entitled to their discovery. If a litigant knows that the material is going to be reviewed, they have a duty, as mentioned previously, to preserve this. Otherwise, this could be considered negligence. The documents in question could have been about another case similar to this one, therefore destroying potential future evidence. Destroying any evidence is damaging to the process of the judicial system, as you know. Thank you.